Okay, so this is LAWS12059 Conveyancing, and this is the tutorial class, and we're dealing with topic 5, looking at formation of contract 1. We've got 2 classes on formation of contract, and basically dealing with some foundation ideas today, and just understanding how the idea of formation is critical to the process, obviously, to a contract of sale, and what are some of the steps and elements in that. And then we look more closely at some of the statutory matrix in the second class on formation next week. All right, well, given pressed for time and so on, we'll just go straight into the tute problems. I also just say I've done an Echo 360 recording for this class, and it'll be uploaded shortly. Just been having a couple of technical issues with the upload process, which I've tried to sort out with IT now, so hopefully this was for both this course and land law, that those recordings will be up there. All right, so just let's have a look at problem 9. And Grant, do you want to just walk us through that?
Problem 9, I'm just going back into the question to discuss the interconnection between the authenticated signature fiction doctrine, the requirements of the statute of fraud as operative in Queensland, and the Electronic Transactions Act in relation to proving whether a contract for the sale of land has been duly signed.
So basically, I mean,
what I was getting out of that question...
Yeah, you go. Sorry, you go.
Sorry?
You go. Yep.
I was going to say what I was getting out of that question was to examine the technical requirement as to what constitutes writing, what constitutes a signature, particularly as we move into the electronic age with electronic conveyancing. So that was sort of, I guess, what I had in mind as I was looking through writing my response.
Yeah, I mean, this question, I've framed it, in such a way to, firstly, the signature on the contract of sale, like, in many documents, in many legal transactions, in many legal processes, the fact of the signing, the signature by a person who is involved in a process, or in this case, a party to a transaction, it's critical, okay? It indicates acceptance of the document that, the wording in the document that precedes the signature. Very often, you're signing that you've understood the contents hereof, you accept the contents hereof, and you're signing that this is in this context, is a contract you're entering into. So it's always been fundamentally critical to recognising that you are becoming a party to this contract, and in this context, contracts for sale of land, significant. But of course, in any situation, contracts, the signing, the execution is critical. But putting it into the context of the statute of frauds idea as relevant under the PLA today, the Property Law Act in Queensland, in terms of the requirement for writing. So not only the signature idea being important, but the requirement for writing, and what type of writing, and what does that mean? And then, as you indicate quite rightly, we need to contextualise this into the modern environment. So it's no longer relevant to just talk about the signature idea as it exists in the history of discussion around that process and the case law that looked at that, where we're actually looking at a different situation today, where this is in the e-space, basically. And then we have to ask questions about the impact of that e-space and the technology. What does it do? How does it change things? And the other thing is, what I would like you to do, and this didn't really come out actually in any of the responses, is don't be backward in engaging here and saying, what do you think? Do you agree with the way the law is dealing with this in this evolving space? Because that's what we're in. We're in an evolving space here. We don't have all the answers to the challenges and the problems that technology is presenting before us. Even, come back down to something quite simple. In doing the things that we do in this course and in our online degree, we often encounter technology issues and technological challenges on both sides of the table, both for me as the educator and for my students. And often it's an evolving process of how we resolve these, how we get around them, how we get what we need to get done, and we use the technology in a way that allows us to do that, but we overcome the hurdles, we overcome the barriers. In this context, that's partly what we need to think about as well. But don't be afraid, don't be backward in critically engaging with that and saying, well, look, this works, this doesn't work, this is okay, this doesn't go far enough, okay? Now, the ETA, for example, and I'm going to just go back to you in a minute, Grant, but the ETA was enacted in 2001. Right? We're now in 2014. And in the elapse of 13 years, technology has developed dramatically. Right? So, and yes, the ETA may have been amended a little bit, but that's in law that's not a very long space of time. But in terms of technological development, that's a huge development, a huge change that's taking place. So, just what any thoughts on that in terms of how the law is dealing with the impact of technology in this area, particularly with regard to authentication of signatures and the importance that they play, and any comment on impact for probably law act requirements and things like that? Thoughts in that regard?
An initial thought, and this is partly because of something I've been reading, is I think that the law is slow to keep pace with technology. That you look at, sort of, I've been reading about click wrap, where you basically accept a contract. That is your acceptance signature. It's certainly in the United States, it's a binding contract. It appears to be a binding contract here, and as much as that technology has been in place now for nearly a decade, there is almost no, I actually couldn't find Australian case law to support sort of arguments about the concept of click wrap. Yeah. So again, that just to me is a good example of how technology has developed, and it has, we're talking about now a time gap of 10 years, and we're not seeing anything through the courts yet to make
that's right.
rulings.
That's a nice example, a bit off from this, but a nice example. And the other thing too is, as you would know yourself, is that commercial entities that are providing services or providing goods, but it can be both, but increasingly I think it's in the context of services, they're not backward in coming forward with a whole raft of terms and conditions in a contract to protect themselves legally that they're requiring you to agree to. So that even, for example, when you want to access technology, you want to access iTunes U, for example, if you've got an iPhone or an Apple device, you want to access apps, or you want to get access to information. Very often there's this great, long, enormous number of terms and conditions that have been carefully developed by lawyers that you just scan through, and most people would just scroll the scroll bar right down to the end, click on accept. But by clicking on accept, you actually are accepting all of those terms and conditions, and you are actually acknowledging that you have read and understood the contents thereof, including links to other electronic documents that are hyperlinked from those terms and conditions and not found within the terms and conditions themselves. That, to me, is a very good example of a disconnect between, on the one hand, what the law is doing with regard to the contents of the contract, the explaining the aspects and features of what's needed, and how it's working in the technological space. I would suggest it's actually not working because people aren't reading all those terms and conditions, and that actually is to their detriment. But those large organisations are not backward in developing great long rafts of conditions and so on. Does that have any application in the context of what we're looking at in problem 9, do you think? Particularly, for example, when we think about electronic conveyancing and the fact that the contract of sale going forward, not entirely now, but going forward will be entirely in electronic form?
I think it does, because the electronic signature to me is comparable. Reliance then becomes not on whether I think the party has in fact read the terms or impliedly accepted them simply by clicking or lodging that electronic document. This is where I think the law seems to be, through examples like the ACL,
Yep.
By implying terms that, to a certain extent, it doesn't matter what the party actually puts in those terms. If the law says, well, we'll disregard unconscionable and unreasonable terms, well, then that seems to be the consumer protection that takes place, as opposed to trying to find a way to understand every term and condition that's in these very long agreements.
That's right. And the other thing with regard to contracts of sale, we haven't really got too much into the actual framework of the contract itself, but we will very soon. But you will have seen versions, if you've gone onto the website that I've given you access to, or on the course website. The contract, the 3 versions of the contract, standard contract of sale in Queensland, they are standard terms. There are printed, I use the word printed in the context of the electronic space, but they are a standard, let's say, standard form contract with standard terms. Now, as we will see subsequently, there can be amendments to that and so on. I mean, going back to that illustration or the example you gave, Grant, of clink wrapped situation, and then I've talked about the long list of terms and conditions, and then clicking on accept. We already have challenges with clients and purchasers and vendors actually reading all of those terms anyway. All right. The reality often is they leave it to their lawyers, which they shouldn't. And the lawyers need to explain this to their clients. The clients need to read this. It's their contract. How much more challenging will that be in the electronic space, where all they prospectively will be able to do is to click something which will indicate that they have read and understood the provisions and content thereof?
This is actually a subject that I've chosen to pursue in the assignment for the 3rd question. So
I look forward to that. I look forward to reading the response. And the other thing I'll just say to you, because I know you're not in Queensland, is that not the developments in the e-technology and in electronic conveyancing is at different points in the different jurisdictions around Australia. And I've done work, of course, previously in New South Wales and continuing to have engagement with legal profession in New South Wales on these issues. And just need to be aware of that the development of this, the changes to e-conveyancing, fully fledged e-conveyancing, is at different points in the process. Queensland is actually, I think, I say this, I think it's a fair thing to say, quite advanced and it's not certainly fully fledged at this stage, and everything's not electronic, but it is fairly advanced, I think. But not every jurisdiction is at the same point. But there is a great insistence for everyone to get on board and move forward with this. We certainly have a regime, and it's underpinned by legislation in the various states and a national framework. So significant issues here. What about the just go back a little bit, and I know you made some observation about this in your response, on the response you posted. The authenticated signature fiction. Just want to talk a little bit more about that.
Well, I think the authenticated signature is that it's a fiction to have a physical, handwritten, hand-scribed signature, in the sense that what you require is an acknowledgement and an agreement from the person. So you could handwrite it. It doesn't have to be a cursive scribed signature. It could be printed letters. It could be some type of marking. So it's a fiction, and I guess in the modern age, you could simply cut and paste a signature and paste it onto a physical document that would be very difficult to detect by people as well.
Can I just ask, what's your thoughts about? I mean, what you've said about the authenticated signature fiction is accurate, but I want to throw in something a bit from left field here, which terribly unlike me to throw in something from left field, but anyway, I'm going to. What do you think the circumstances are if we're dealing with an illiterate person here?
I think that provides a good example. One, there is the existing potential for fraud as it is, but it certainly, it may exacerbate in the sense that somebody can more easily click on a signature, an electronic signature, and submit something, not understanding what it is that they're submitting to. At least if there is a handwritten signature that requires an effort to review, to understand, to present, somebody could explain it to you.
Yeah, that's right. Of course, you know, this also a little bit moves into the idea of contractual capacity. But you know, we assume that the person does understand what they're doing, it's been explained to them, and so on and so forth. It just, the point really here is that the technology, I think that we have to appreciate that the technology brings opportunities. Of course it does. It brings wonderful opportunities in a whole lot of ways, but there are challenges there as well. And we must appreciate both of these and keep the balance right. These requirements that have been developed historically in the law, and of course the statute of frauds goes back to the 17th century, so that idea of writing and the requirement for writing was always very important, particularly with respect to transactions concerning land and signatures and so on and so forth. And, you know, the new apparatus of how that takes place, the updated legislative in context, which updates the provisions, incorporates them into modern law and whatever. But this basic idea that the person needs to be executing the document, which is the thing which is what binds them in this process and in this transaction, and that they understand that, and that they understand what they're actually binding themselves to in this significant transaction underpinned by the contract. But within the electronic space, this whole process can be speeded up significantly on the one hand, but that runs the risk of people actually, you know, getting things done more quickly, but understanding what they're doing less and less. I think arguably, I'll toss this question back to you. What implications does it have for the legal practitioner in the conveyancing process? Your thoughts on that?
It places more responsibility on the legal practitioner to be more diligent in explaining terms, because their clients are simply not going to read documents, they're not going to read through it. I don't necessarily think that the electronic environment would necessarily change that, in the sense that you could, if there is a handwritten or a paper contract that's 50 pages long, I would say that most people like clicking on a website. Most people simply look for the little yellow sticker that tells them where they have to sign.
It's true.
I don't really see it changing. And if anything, just to use one example that is quite current, if you look at the banks with credit card transactions where they've abolished signatures. So instead of signing for a credit card transaction, I think as of this month or last month, you have to use a PIN number. So it's I think, yeah, if anything, I think there's added protection in having to use a PIN number as opposed to signing, because Some people's signatures are relatively simple, and I don't think that people who should be checking those signatures necessarily check. They look at the person, they accept in good faith that that is your signature. I can think in the past I've rarely seen people turn a credit card over to look at my signature on the other side. So if anything, I think that removing the potential for the handwritten fraud by having a PIN number system may even increase security.
What about, I mean, you've mentioned the challenges for clients and the heightened obligation upon the lawyer or the practitioner, and I don't disagree with that. I think that's right and that's important. But let me just press a little bit more. But how does that work, given the fact that technology will also put additional pressures on practitioners and on solicitors, legal advisors, to be even more efficient, to produce more volume in terms of the fact that they're part of a business? Because law practice is a business. It's not just, you know, back in the days of Jardine and Jardine in Dickens, right? You took a, you know, however long you took to write out the document in copperplate, right? So what about that issue? What about the pressures on practitioners? All good and well to talk about their heightened obligations, but how are they going to meet that with the pressures to be more efficient and to create more volume and therefore to make the business of law actually even more profitable?
Well, that, in terms of increased volume in terms of transactions, I understand that, but in terms of the change from a manual environment to an electronic environment, the solicitor is still going to have to review the same information. So I don't necessarily think that adds a burden to the solicitor. But if you're talking about the production line, that in that electronic environment with speed and efficiency, the expectation is that they take on more transactions and more work. But I've actually been thinking on that subject already, that I wonder whether, as governments do, as systems become more automated, that then they deregulate and they may expand, and they may sort of reduce the pressure and transactions going through solicitors. They may encourage the independent conveyancers and or maybe reduce qualifications to cater for what is a simple system.
Look, that's very timely to bring that up. That conference that I went to in the Gold Coast last month, the Australasian Property Law Teachers Conference, there was a colleague there, I think it's from Singapore, Hong Kong, but recently returned from spending some time in the UK studying legal practice and legal practice context there, where the UK has moved to a situation where they actually license legal service now. They don't actually license practitioners. So you can actually find, and you do find, that practitioners are, and legal services are being provided out of shopping centres, Tesco, big shopping centre, a big shopping supermarket chain in the UK, and others. The whole environment of the provision of legal service has undergone a revolution. And I suspect that there's going to be dramatic changes in the Australian landscape as well, not yet upon us in that way because we still license practitioners. But the other thing too is in the context of a conveyance. So for example, I know in your case sitting in regional New South Wales, the opportunities of e-conveyancing mean that unlike in the past where you'd be limited to clients who could only clients that could physically walk in the door in that area, and therefore most typically, and because of everything being paper-based and the way that it was arranged, mostly dealing with transactions involving sales and purchases in the local area where you were located. Suddenly now you can deal with transactions wherever. You can deal with transactions in Cooper Pedy, you can deal with transactions in Cairns, you can have a client in South Australia wanting to purchase an interest in a unit or a lot in somewhere in North Queensland. You're sitting in regional New South Wales. You can facilitate the transaction. You may well be doing it because they've used you, they've been a client of yours in other matters. The whole environment dramatically changed.
Sure.
So
just one thought though.
Yep.
In past dealings, I have very, very rarely been into a solicitor's office. I have gone into a solicitor's office, for example, to verify my identity when signing a document, if that's been on the purchase of a property or whatnot. But all correspondence has been either by email, telephone. I mean, I'm in my 40s, so in the past by fax. And even going back to sort of, you know, exchanging information by facsimile.
Yeah.
The only time I would ever go into an office would be if I had to physically sign a document in front of them so they could verify that I was the person signing that document. Otherwise, very rarely. So I'm not sure how much of a change there really is. Just instead of posting documents, couriering documents, now it becomes even faster electronically. You simply don't fax 50 pages, you email 50 pages without printing it.
Yeah. That's a good point to make. And also, you know, this is also really about matters of cost, because to actually physically meet with a lawyer, it's much more expensive than to have a telephone conversation with them. But, you know, depending on the nature of the transaction, they can be billing you according to scale, or they can be time costing you. So that's, you know, a good point with regard to the degree of contact, and it depends on the nature of transactions as to, you know, how much contact, physical contact you have with the practitioner. But, yeah, no, that's a good point. But so just wrapping that up. Sorry, go on. Yeah.
Sorry, I just coughed.
Sorry. Just wrapping that up. So that question was getting us to look at the role of the signature and the fact that even before the advent of technology, the law recognised that there are there are various ways in which the signature could actually, or the signature requirement could be met, and that's where that authenticated signature fiction doctrine came from. The idea of the statute of frauds, the requirement for writing, been there for a long time in the law, how it's now reflected through the current legal environment, and also just thinking, as ever, about the advent of technology and the law's response thus far through legislation, through the ETA Queensland Act. But the point made earlier by you, Grant, I think is useful in terms of the law often lags, particularly in the, you know, with regard to technological change, and that's something that we need to be ever mindful of. All right, now let's move on to problem 10. This is revisiting something that's probably quite familiar to most of us, both in terms of your contract law studies generally, and in terms of property law, and we looked at this area of equitable estoppel in LAWS12059 Foundations. And again, it's been, you know, tossed up here because of the role of equity in dealing with situations and circumstances where we in fact don't have the requirements of writing met, and we've got some case law there. So maybe you just have a bit of a go at what you want to say about the role of equitable estoppel in regard to sale of land transactions, and if you want to refer to a bit of the case law to explain how it works in this context and why it's important. So have a go at that.
Well, equitable estoppel in, I guess, the simplistic form is where somebody makes a representation or infers or leads someone to believe or creates a situation that that person makes a reasonable assumption based on what they've been told, and they rely on that assumption or representation to their detriment, So Walton's is a good example, and where it was indicated to them that the contract was complete. It just needed to be finalised through solicitors. So they demolished a building. Obviously, they incurred a significant detriment in doing so, and equity steps in to say that it would be unconscionable just because they haven't complied with that final execution of a written document, that they have certainly led that person to their detriment, and therefore the equity stops them from denying their obligation.
Yeah, no, that's right. Of course, the Walton Stores case was in the context of an agreement to lease, which is interesting. We'll talk, in a couple of coming weeks about leasehold interests in land law, for example, and the difference possibly between a lease as a proprietary interest on the one hand and an agreement to lease on the other. But that was Walton's case. Do you want to say a little bit about PowerCell?
All right, that's the one that you picked me up on already today.
Have you got the textbook nearby?
I do,
yeah.
But I have made a quick response in regard to PowerCell.
Oh, okay, all right, good.
That essentially, in terms of defining the limits and the conflict, or this is my take from that case, where you have the statutes of fraud, although it's been reenacted in other legislation. That statute of fraud's requirement that land transactions have to be reduced to writing and they have to be signed. That in itself, statute defeats the common law. So in terms of equity, it becomes somewhat irrelevant. And that's where there was that, what I got out of that judgment in that case was that the justice was saying that simply to make an oral promise or an oral agreement, that's only one component. You have to lead that party through more than just an oral promise or an oral agreement to indicate to them or lead them to believe that you're going to honour that oral commitment. So there has to be something more. And that if there isn't that second step, if there isn't that extra bit to take it that step further, well, then it's not inequitable or unconscionable to basically rely on the law of the land.
This is, I think, a good example, firstly, that, there needs to be a clear indication that the statute of fraud's requirements, now, the PowerCell case, of course, coming out of New South Wales, so in New South Wales, the relevant act is the Conveyancing Act, but the equivalent of that for us in Queensland is the Property Law Act. We're saying basically that it must have been understood that that formality requirement was not actually going to be relied upon, and that it was enough, the oral, what was communicated and dealt with orally would be the basis of the transaction. And but as you said, the second aspect is that there has to be the proven elements of features of equitable estoppel before equity will intervene, and also what amounts to unconscionability, acting against good conscience or acting in an unconscientious way, has to be established. Now, I think one of the interesting things that happens here is that the courts, this idea of unconscionability is both interesting, powerful, but also maybe and arguably, in some senses or in some circumstances, has the potential to be a little bit, maybe dangerous is too strong a word, but it's clear, I think, from many of the decisions that are looking at unconscionability that even though it's often identified as a key aspect or a key notion, we don't want, the judges often very, very committed to the position, I think, that this is not without bound and that there are aspects that we have to establish before we can say that we have unconscionability for the purposes what equity requires. We're not talking about just broad, bounded ideas of a lack of fairness or a lack of justice in a very broad and unprincipled way. But there are, aspects and elements we need to establish here before we can say that there's been unconscientious behaviour. Having said that, that proviso, if you like, leading into the idea of unconscionability, it's really it is the case that the idea of unconscionability is very powerful and very important, and goes right to the heart of what equity is about. And it will not allow somebody to have proceeded in a way that, if you like, is exploiting the reliance on the representation, where there's a detriment by that party relying on that representation, and being trying to use the technicality of the law, if you like, to allow that to occur. So yeah, I mean, any further thoughts on that?
I think that sort of relates to the subject of indefeasibility, in the sense that I can't think which case it was, but where the court held that it's not unconscionable for a person to register a title knowing that there is an unregistered interest, so long as they haven't made some other commitment in accepting that interest, to take advantage of the law. If the law allows them to defeat all unregistered interests by registering the property, then that's their good fortune, whether it's necessarily ethical or not.
Well, of course, when we move across, it's hard sometimes to completely differentiate these areas because there is an interconnection. But in that area of land law, of course, the idea of indefeasibility acquired on registration of an instrument or an interest as acceptable under that system, that's what you're really running up against. So that on the one, and the fact that the interest is created by the act of registration under the Torrens system, and to allow unregistered interests to impact upon that, to defeat that, if you like, that's been considered not to be acceptable, even though it can affect the quality of the title in various ways, as we've seen, as we will see further as we go down the track of our land law studies. But you're right in identifying the dimensions here, and the role that equity plays in land law and in the recognition of interests in land through legal instruments has been not a completely, has been an area not completely, that isn't fraught. And what the law has done is it's tried to strike a balance. I mean, in Queensland, for example, we have the unusual situation, which is not replicated in other jurisdictions, of where we have a recognition of equities in the legislation itself. That's in the LTA, the Land Title Act. It's very interesting that the debate continues to be of these, and there's not a lot of debate in the context of that particular approach in Queensland, which, as I said, is not universal across the jurisdictions. But not a lot of debate about the fact that, given the fact the statute recognises through specific provision in the legislation these types of interest, does that change the nature of the interest? It talks about the equity or the equitable interest, but does it then become a form of statutory interest because it's recognised within the four corners of the legislation itself?
I'm digesting that thought.
That's a rhetorical question, I think, or as you say, for reflection. There is if you look through the debate, right, and look through the material and look through the resources and even the further references and the readings and endless articles and what they're referred to. Very great paucity of identification of that way of interpreting it, actually. And I think one of the reasons is because it's actually quite different to what's done in most jurisdictions. Most jurisdictions, we are talking about something that is, if you like, off the legislative system. And what's happened is we've got a recognition of these interests that have historically always been recognised, and the law saying that they will continue to be recognised, but they have to work within and work with the implications of the registration of the interests recognised through registration under the Torrens Act. But where that framework is different under the actual Torrens Act itself, arguably that leads to a different outcome. It's just something, yeah, interesting to mull over and reflect upon. All right, so did you want to say anything further about problem 10?
No.
No. Look, I you know, sorry.
I'm happy with, I think, the the general concept.
Yeah.
Yeah.
Look, it's not a new concept. It shouldn't be new for anyone doing this course. Tried and true part of contract law, and also our earlier studies in property law. But we just need to be aware of its role and its context and its importance in the context of conveyancing transactions and contracts for the sale of land, and that's why it's there. And also to remind ourselves that equity continues to have a role in this area. Now, in the day-to-day cut and thrust of transactions involving contracts of sale, conveyances and so forth, you know, matters of equity are not in the forefront of one's mind. Certainly not for clients, I can tell you that, in a legal sense. I mean, certainly they're looking for equity overall, but you know, their idea of what equity means is a bit different to what our idea of equity is in a very legal or clinically legal way, if I can put it like that. But as practitioners, we do need to remind ourselves that this is a continuing feature of the law, and we never know where it may surface or may arise, and we need to be aware of its involvement and its context in this area. All right. Well, look, I'm happy to leave it there. You got any further questions, Grant?
Not today, I don't.
Okay, that's right. All right. So that's good. Thanks for that. That's formation of contract, the first instalment or the first class. Next week we'll move on to second instalment, if you like, on formation of contract, where we'll look more closely at the those areas dealing with the statutory requirements with regard to the sale of residential property, and the second part of chapter 4 of your textbook. So, bye for now.
Thank you. Bye-bye.